Thank you for listening to Lone Star Community Radio. This program was broadcasted and recorded live from the LSCR studios in downtown Conroe, Texas. Lone Star Community Radio is supported by listeners like you. Donate and sponsor today. For more information on getting involved with Lone Star Community Radio, contact us at lscrstudios@gmail.com or visit us online at www.irlonestar.com.
Welcome to the Legal Connection Show. I'm Toni Collins, an attorney in Texas, and the Legal Connection Show airs every Tuesday at noon on FM 104.5 and FM 106.1 on the band that's for Montgomery County. And if you drive outside that band, or if you missed it and want to listen to the show later, we are also on Facebook, the Legal Connection Show, on YouTube. You can Google the Legal Connection Show. And if you go to irlonestar.com, you can get all of our this particular show and any of the older shows. Last week, we covered the first part of property tax appraisal protest. And it's just the right time of year for that. So this is a timely show. If you need a few pointers, I'm going to give a shout out to my friend Krista Ward, because she's the one that kind of really gave me the spirit and enthusiasm to promote protesting your taxes. Because before I thought, well, I'm not going to protest if it's kind of close. And she being the up-and-coming real estate developer that hopefully one day I will be after I graduate from Texas A&M's master's program in land development, she was basically like, you always protest them. And she was right. And so I protest all my property taxes, and not if it's marginal or if it's in my favor, I'm not going to protest it. But generally that hasn't happened yet. Also, lost my train of thought thinking about how the things are. I protest for other people. But as it stands right now, protesting your taxes is managed, maintained, regulated by state statute, and the counties generally have to follow that. Not generally, but expressly have to follow that. So we're going to go over some of the rules, and on part one, we went over a lot of those rules. Part two, we're going to have frequently asked questions that I think are a little bit more fun than just the bland going over, step-by-step process of how to protest your taxes, because it kind of makes you think. And so let's just start the show. Just a brief recap is that one of your most important rights as a taxpayer is your right to protest the Appraisal Review Board. You may protest if you disagree with the appraisal district value or any of the appraisal district's actions concerning your property. If you're dissatisfied with the Appraisal Review Board, and they're the people that are making the determination when you protest your taxes of what its actual market value is, you have the right to appeal their decision. Any ARB, and that's the Appraisal Review Board's decision, can be appealed to the state district court in the county in which the property is located. Depending on the facts and the type of property, you may be able to appeal to the State Office of Administrative Hearings or have a binding arbitration. And what we went over last week was not only the details that and the qualifications for when you could go to the State Office of Administration or binding arbitration, or just basically how you assess which one you want to go to. And the general consensus on usual facts are that you would go to your county and do it online, because that's the simplest way if you've got a busy day. It's always best to do any hearings in person if you can do it, if you have the time to sit and wait. Harris County, it is a zoo. You're in a long line. You pick a number. You're waiting around for, however long it is. Even though you've got a set time, you're still having to drive all the way out there, park, get there, get your ticket, wait in line with everybody else that was set at the time that you were in person. If you get a Zoom in Harris County, which is my favorite way to contest or protest my taxes in Harris County, is you are in a holding room, but you can kind of putz around your house and do stuff while you're in the holding room, as long as you're within earshot of your computer to know when they call your case. And when you do it online, it's or have your protest online, you can pretty much in live time email your exhibits. That's not what they say the requirements are. They say it has to be 5 days ahead of time, and it needs to be, either mailed in within a certain period of time and a certain number of copies, or you can email it and they give you all the instructions. I have found, though, each time that I have protested my taxes in Harris County, that and I've always done it in person in the other counties, that they will let you email it right then. They're pretty lenient with you if you're pro se and doing your own taxes. But you have to have it ready. You can't just say, oh, let me go get it. You need to have it ready in a digital form to be able to zap it right over to them, either before the hearing, which is preferable. It makes you have a little bit more reliability, rather than waiting and having to collect it and say you'll get back with them, because they may not postpone it, and then you don't have any evidence that's admissible for the review board to look at. All right, so that was when I do Montgomery County. Montgomery County has been beautiful. Every time I have protested my taxes in Montgomery County, you first go to the informal hearing. You meet with an individual, usually in a small office or even a workstation. It's private, but it's one-on-one and it's impersonal. I mean, very personal, not impersonal. And they just kind of talk to you. They each put a screenshot of Google Earth of your property so they can see what's going on pretty much. If you've done any updates within a time frame when a satellite has captured it, they can see. You can't say the property burnt down or it's in bad condition if there's the Taj Mahal on it now. So kind of be aware that you really kind of want to tell the truth, because they can verify this, and they will send people out if they think they need to. So to verify that if they don't believe you. They haven't in my case. I've been pretty honest. You go up there and you have your screen shot of the property you're contesting or protesting the taxes on, and you've got to be ready with what the market value is. You've got to have your comps. You've got to have looked at what their comps were. You can get those by filing your House Bill 201 request, and you need to do your research beforehand. You go in there and be ready to show. Just like you're negotiating for a car. This is why the market value starting January 1st, 2020 to December 31st, 2020 shows that my property, I think it's actually 2021 now. It's all the year 2021. Gosh, I always get that confused. They're evaluating your property for in 2022 for the 2021 taxes. So I stand corrected. It's January 1st, 2021 to December 31st, 2021. That's the market comps that you have to use. And they have to be very close comps. And so your best bet is to go to HAR online, or to actually, if they don't have that property, to have the person that bought the property attest, to swear that they bought it for the amount that they said they bought it for, if they don't have that in their 201 records that they're using as a comp. So, you're basically fighting them. It's your burden of proof to fight them that your property's value is lower. If your property value is lower, you can't lower the percentage of the tax, but you can lower the tax you pay, because the percentage of the tax is based on the property value. So you're fighting the property value, not your hardship, not last year's sales price, what you bought it for. You can fight the improvement condition, because that's part of the value generally. If it's worth nothing, you can say, regardless of what taxes you paid on it, the improvements are 50 years old, they have no value. They may believe you if you can show that. And then everything is land value. Land values have skyrocketed, particularly during COVID, when everything went up, when I guess everybody was buying property because they were staying home. Who knows why land values have skyrocketed, particularly in the Montgomery County area, one of the fastest growing counties in the United States. So you don't want to fight your property market value. It's going to be a little bit more difficult this year because property values have gone up. Sales prices were going through the roof, but don't feel like that's a hardship to you. If, like some of my clients, your property is next to a mortuary or the dog pound, or the improvement has just burnt down, literally, and you didn't burn it down yourself, not insurance fraud or anything, then you've got a good case, and they're very reasonable. The appraisal review board are citizens just like you and me that are appointed, and it's the board are basically the county appointed panel versus the appraisal district, who's one person. It's the chief appraiser, but I believe they must have a lot of chief appraisers, because they couldn't be conducting all these hearings at once if they didn't. And then it's you. And you can have somebody that is not an attorney represent you in your protest. You can hire a company to do it. Beware when you sign up for a company to do it, though. It may have a provision in there that you don't see, because a lot of times they're hidden, that they can renew it automatically if you don't cancel it. And usually these companies say, you don't owe us anything unless we reduce your taxes. But what if they only reduce it by $1 and you accidentally forget to renew? So it seems to me, if I remember correctly, there's a fee for them to reduce your taxes, and it's not reduced from the amount that you owe them. So if they charge you $500 to go fight your taxes and they reduce it by $1, you've now got a net loss of $499, although your taxes are lower. Your tax reduction only applies to that 1 year. And while the tax reduction on your property applies to more than 1 year, if they can get your homestead, your residential homestead reduced, because that's got a cap of 10% escalation per year, it's still, you need to look at your numbers to make sure that it's still economic for you to hire a company rather than do what I'm going to teach you how to do today and go informally protest your taxes yourself. And again, if you're not happy with what the first informal tax review person tells you, which you want to do that because you want to get a feel for what they're going to argue, then and be very polite, say, I'll know each other. Then you go to the appraisal review panel. And if you're not happy with what they determine the value to be, you can, what they were talking about and what I just read to you about the property tax process, is you can appeal that to a state district court, and you might qualify to appeal it to the State Office of Administration or ask that it go to a binding arbitration. Normally, if you file in the state district court, you've got to pay a filing fee. I believe it's like $180 just to file that and get them served. Service you can do on your own if you get someone to serve that's above 18 that qualifies under the statute. That's usually somebody that's disinterested, to hand it to the party that is the registered agent for the county, and usually that they're very lenient about that too. You can probably just hand it to the person at the front desk, but or you can call the show and I'll tell you who that is, so you can get it served to the right person. But if you pay someone to serve it, it's usually about $75 to $100 for service. So you're now looking at maybe $280 just to file it. And then if what normally district courts will do is they'll ask you to go to mediation. There'll be some discovery that's exchanged, not a lot. It's very standard in these tax protests. But I very much advise you to go to the Montgomery County Resolution Center. It's called the Dispute Resolution Center. It's right here off of 105, which is West Davis, and right across the street from the courthouse. They have a stepped down pricing scale depending on your income, so it's the most efficient, and they're very good people. The arbitrators there are not the arbitrators; they're the mediators there. Especially during tax protest season, will be able to be a voice of reason for you or for the district if you feel like you've been done wrong, and or your appraised value, not that you've done wrong, but your appraised value is not what you would like it to be, which is generally going to be lower. And of course, from there, if you don't like that, you can, if there's some, legal error and you go to court and lose, then you can always go the typical appeal process, which is to the interim appellate board, which is going to be the 14th, the 1st. In Montgomery County, it's the 9th Court of Appeals, but it could be the 14th, the 1st. If they're too busy, then it gets moved over, transferred to the 13th or another county that doesn't have so many appeals going on. And then after that, if you lose there, you can go to the state Supreme Court of Texas if there's some actual legal error that is of such a concern to all people in Texas that they might grant a writ to review that. And then if you lose there, you can go to the United States Supreme Court. And the odds of you getting granted certiorari because there's a constitutional issue on that are, pretty much nil on a tax protest. I don't think I've ever seen a tax protest go any case that's gone to the United States Supreme Court, but I guess it could happen if there was some kind of a constitutional breach or violation, discrimination or something like that. But That's the appellate process. What we're going to go back to today is frequently asked questions. Now, so you ask, what is an ARB, an appraisal review board? An appraisal review board is a group of citizens authorized to resolve disputes between taxpayers and the appraisal district. The ARB hears taxpayer protest. The ARB also hears issues that a taxing unit may challenge about the appraisal district's actions. So they're basically, if you have a complaint that not only goes to the market value, or maybe you were served wrong or whatever, this 3-member panel is who is going to hear whether or not you have a legitimate complaint. They're not going to hear stuff that's off in left field. They're going to listen to the exact complaint you have and what law and facts you have to support it. All right? So it's pretty black and white. In taxpayer protest, the ARB, the Appraisal Review Board, listens to both the taxpayer and the chief appraiser. The Appraisal Review Board decisions are binding only for the tax year in question. And ARB hearing begins around May 1st, and right now we're at this. We're recording this on the week of June 19th, Juneteenth. So you still, and we talked about this in the last show, you still have a chance if you've missed your deadline to file a protest to move to allow you. I guess it would be for that relief to allow you to still have an opportunity to protest, and they'll probably grant that relief to you. The ARB decisions are binding just for that tax year. The ARB should complete most of the hearings by July 20th. In the largest counties, the deadline may be later. I can tell you by firsthand experience that I've appealed many counties and many different properties. I've only so far been set for 2 informal appraisal reviews out of a multitude of ones because everybody's protesting their taxes this year. In one, I was in the informal Zoom hearing with Harris County. I was told that I didn't have the proper form file to represent a client, which I was told that I didn't need to file a form if I was an attorney and I'd represented them before. But don't go by that. It's not a big deal. It was just the informal hearing. So I filed that form, and they have not given me a new date yet for the formal hearing. So I got a feel for what they were looking at. And I got to chit-chat with the informal representative for the appraisal district, which was really good because we talked about the property. So it wasn't for naught. It was a good time efficient use of my time for this particular project. And then in Montgomery County, they had set an informal review for one of my properties very early on, and before I had the chance to receive my House Bill 201 records that would show me what they were using as their basis for my extremely high market value. It increased like 300%, which is to me insane because I don't think any properties have gone up 300%. But good if I were selling it, bad if if I'm paying my taxes and I'm not selling. So anyway, so this lets you know that all appraisal review hearings apparently, because there's so many, are probably not going to be done by July 20th. Now, how are the ARB members chosen? In counties with a population of 120,000 or more, members of the ARB are appointed by the local administrative district judge in the county in which the appraisal district is located. The board of directors appoints ARB members in all other counties. So I believe that Montgomery County clearly will have a population of more than 120,000 people in it. It seemed to me we had, I don't know what our population is. It was because we had to have a certain floor, so to speak, of people in order to exceed the benchmark to be able to argue whether or not a city could automatically annex any of their extraterrestrial territories and Conroe and Montgomery County exceeded that. Conroe exceeded that. So the county, and I think it's the county, it might be the city. I'm not doing that show today, but if in this county right now, if you live in the city of Conroe and in Montgomery County too, I believe it's going to cover the whole area. But don't hold me to that. I can't remember right off. But I know that we are we're not even in an ETJ, and we're in Montgomery County, but not in the city of Conroe, where I actually live. And some of our other properties we own are in Magnolia, but not in that ETJ. So we kind of fall in this kind of county no man's land. We can't be annexed into any cities, whether it be the Woodlands is not actually a city, and they voted not to be annexed anyway. But the city of Conroe, the city of Magnolia, and any other cities could not annex in your particular subdivision unless there's a vote and 50% of the members of that community agree to it, which was a beautiful legislative action and law that was recently passed that really protects everybody, because a lot of people don't want to be annexed. And we, in our particular subdivision, we did not want to be annexed. We didn't feel like it was beneficial to have, we already had all of the amenities that we needed within the community. We didn't need the city to pick that up and charge us twice for it. So anyway, going back to that, I don't know how many members, how many people are in our population here in Montgomery County, but I'm certain it exceeds 120,000, so this would apply to us. And our administrative judge, and for the life of me, I can't remember what his name is, he appoints the appraisal, the ARB members. So I know there's a bunch of them. I don't know how they get sworn in, but maybe it'll talk about it in this comptroller.texas.gov article that I'm using as my basis. And if I misspeak, or if you want to read more about it, definitely go to comptroller. It's I guess HTTP, semicolon / comptroller.texas spelled out.gov, and then go to property tax assistance. To be eligible to serve on the ARB, an individual must be a resident of the appraisal district for 2 or more years before taking office. No special requirements are necessary. However, an individual cannot serve if he or she is related within the second degree by blood or marriage to a person engaged in appraising property for property tax purposes, or a tax agent paid to represent the county property owners in proceedings at the appraisal district. So basically, you can't. If your uncle's on the appraisal board and does appraisals, you can't be on the board, because that would be sort of collusion. It's too close. It's not within an arm's length. The next thing that you can't be is you can't owe delinquent property taxes to a taxing unit for more than 60 days after the date delinquency is known or should have been known, unless it is paid under a delinquent tax installment agreement or has been deferred or abated. So pay your taxes. You can't be on this board unless your taxes are current. And a lot of people say, well, I'm fighting my taxes, and so I'm current to the year that I'm not, that it's not pending. That doesn't count. You pay it, and then you get a refund if you're past that period when they were due, if you win your case. So you have to pay if you want to be on if you want to be appointed to one of these boards. You can't be one if you're related within the third degree by blood or second degree by marriage to an appraisal district board member. So you and your sister, cousin, uncle, looks like a large number of people. Maybe this would not apply it seems like in some of the more remote counties where I know everybody's married to their sister, but here even if you're married to your sister and it is legal, you can't be on the board if you are to be on an ARB member. Another one, no, is an appraisal district board member, officer, employee, a taxing unit governing body member, officer, or an employee or a comptroller employee. So you basically can't be related to anybody who works for the county in that capacity, the taxing capacity. Finally, if you have a contract or a substantial interest in a business tract that has a contract with the appraisal district or with the taxing unit served by the appraisal district, you can't serve on one of these ARB boards. So that's pretty broad. It sounds to me like they're not even limiting this against felons and the usual things. You might not be able to be on a jury because you're a felon, but apparently you can have just gotten out of prison for murder and still be on one of these ARB boards if you want to do your civic duty. And the district judge appoints you. So I don't think it's a paid position, but we haven't gotten there yet. In counties of populations of more than 120,000, an individual cannot serve if he or she is a formal appraisal district board of director member or officer or employee. This one may limit you to not being a felon. So maybe not in Conroe. So I might backtrack on that. Let's see, you can if you've served on it, if you've appeared before the ARB for compensation in the previous 2 years. Appeared before the ARB for compensation. So if you were paid in any capacity in the previous 2 years, within the realm of the ARB review, you can't do that again. That's interesting. So I guess it is a paid position. Who knew? Served all or part of three previous terms. All are part of three previous terms as an ARB board member or auxiliary member. So they've got like a term limitation. You can't just as a practice for, more than 3 terms. I guess it would be, since it's each year, I guess it would be 3 years, no matter how much you like it. The Texas Constitution prohibits a person from holding office more than one paid public office. Because ARB members are paid per diem, they cannot hold public office. Now, that's interesting. So you do get paid per day when you work, and you can't be, somebody that's, I guess, an elected official in some capacity. And I guess we just had elections, and we're actually going to do a show on juries and elections here in just a little bit when the elections are a little bit closer. But, all right, so that kind of counts you out if you have been elected. Go find another job. All right. Should I protest? We were going over this previously, and whether or not you need to assess the, economics of protesting your taxes. The comptroller's office says the ARB must base its decision on evidence. It hears evidence from both you and the chief appraiser. Protest issues that an ARB can consider include the proposed value of your property is too high. That's usually the main reason people protest. Ask one of the appraisal district appraisers to explain the appraisal. And you can do this during the hearing, but it's probably better to do a mock trial beforehand. Verify the appraisal reflects the correct property description, measurements for your home or business and lot, and any defects. Gather blueprints, deed records, photographs, a survey, or your own measurements, statements from builders, or independent appraisals to contest the appraiser's decision. Collect evidence on recent sales of properties similar to yours from neighbors or real estate professionals. Ask the appraisal district for the sales that it used. If you protest the agricultural value of your farm or ranch, find out how the appraisal district calculated your value. Compare its information with that of local experts on agriculture. You can call the Texas A&M Agriculture Extension Division. You can actually go to Texas A&M and or do a Google search. They are phenomenal. They will help you. They'll help you quickly. They don't ignore you. They are the best group of people ever. Not only because I'm going to A&M right now, but because before I was going to A&M, they were one of the reasons I went. They were just like the go-to people. I love that group. So you can always call them for information, and they are very happy to help. And compare that information with that of local experts on agriculture, such as the County Agricultural Extension Agent, the U.S. Department of Agriculture, or other recognized agricultural sources. The Comptroller's Manual for the Appraisal of Agriculture of Land can be found at the comptroller.texas.gov/taxes/property-taxes. Just Google it. I think you'll probably get there. And what I will say about the collecting the evidence and presenting it, and then asking for the appraisal district's value. That's pretty much in a nutshell what you need. Your appraised value of your property is based on the land, so you need to make sure that they have the right land up front, just as making sure that the factual information that they have is correct. Are the boundaries of your land as they see it accurate? Are the number of acres or square feet they're using accurate? They could be way off. They might even have the wrong property. So make sure that first is accurate. The next thing they look at is the improvement. Make sure the dimensions are correct. Make sure that, the year is correct. You want to look at everything that they've used to evaluate and assess what your improvement value is. You can have an improvement on real property, and you can have personal property improvements because you're also taxed on your business property. That's another thing that you can contest or protest. But right now, I'm talking primarily about real estate because that's generally what people will protest. I haven't met anybody yet that's asked me to protest their personal property value. So it must not be a big issue. It must not go up once they've assessed that. Probably because you're paying the comptroller and having to file quarterly taxes, at least quarterly taxes when you're making money selling property to the comptroller. You're already paying a sales tax and various other taxes. So the personal property tax may not be something that escalates or is reduced by the appraisal district often, because I just don't see people protesting that. But in order to get what the appraisal district is using, and that's the last thing that's referenced here, ask the appraisal district for the sales that it used. Don't do that the day of the protest. You want to do this right when you file your protest because they need time to email it to you. They'll email you lots of it. You need to look at it. If it's not what you want, you need to email them right back. Montgomery County is wonderful about getting to you their House Bill 201 records. However, they may not give you all the records, or you may be surprised that they don't have good comps, and you want to get back with them if that's the case, just to make sure that they are sent you the right thing. Because if they're way off on their comps, it may be a pretty easy fix for you to show with either the evidence of the real estate board or by actual sales with an affidavit or maybe some witnesses that the property that had the value that they've assessed to your property is completely wrong. And so that's where this kind of comes in. But the House Bill 201, ask for an advance. Don't wait until the day. You want to do your math and put your comps together and have your little picture together and do what you need to do on your Excel spreadsheet to get everything working. If you have somebody that's a real estate agent, I think everyone, their brother is a real estate agent. There is an application on anybody on the HAR, and any member of HR that would be a realtor or broker. I guess a broker could be a realtor is a broker, but they have their real estate agents, and the agents are to the brokers, right? They have access to what's called comparable. It's a little facility that does. It's called a CMA, a comparable market analysis. They can do that for you for like nothing. The problem is it can get pretty time consuming, and you really should pay them for their efforts unless you're working on them with the sale and you feel like this should be part of the commission they earn. I don't know. But it is a lot of work for somebody to do your comps for you. But it's a nice little facility if you can get somebody to work with you on using it, or if you are an agent and or a new one and you haven't done this before, to actually look on the real estate site and put the parameters in there from January 1st, 2021 to December 31st, 2021, and put the little market area in there and use the house as a subdivision, and it will spit this information out for you, and then you can look at the condition of it better, and then do a real appraisal, add or subtract for the landscaping or the amenities and all that stuff. The truth of the matter is that while you might be able to reduce your market value a little bit based on the improvements, the value is just what your taxes are based on. So you have to look at all of this in totality. If you're only going to reduce it a little bit because of landscaping or big oak tree or whatever, it may not be worth your while. If you say, "Oh wow, they've got the wrong thing," I'm $100,000 off. That might be significant, but it might not, because I don't know what. If $100,000 may be nothing if you live in a $3 million house. So, and if you live in a $3 million house, you probably have somebody doing your appraisal protest for you. You're not even listening to the show. So, of course, if you live in a $3 million house, you might be listening to the show because you save your money, and that's why you have a $3 million house. But who's to say? All right. The next thing that you should consider is your property valued unequally compared with other property in the appraisal district? Determine whether the property value is closer to market value than other similar properties. ask the appraisal district for the appraisal records on similar properties in your area. That's the House Bill 201 request. You can do it via email. They'll know exactly what you're talking about. So if you send an email to your appraisal district and say, can you give me the House Bill 201 records that you use for my appraised value on this property, give me your appraisal account number, that's like a one-liner you can send via email to the chief appraiser of your county, and you will get those records. It's that simple. Do not hesitate to get that information. Using that method, you don't even have to send a letter. You don't have to put a stamp on it. It's all email. Let's see. The comparison between the values that they have and what you've determined may show that your property was not treated equally. A ratio study or a comparison of a representative sample of properties appropriately adjusted for determining the median level of appraisal must be prepared to prove unequal appraisal. And I'll tell you this, when I go in and I'm ready to fight the appraised value, you better have a number. That's one of the first things that comes out of the appraisal board's mouth is, before they see any evidence, they just want to see what we're fighting about. They say, this is what it's appraised at. Do you agree that this is the perimeters and this is the house and this is the year? And we kind of get, we establish, the facts. And when you're in court, that's called, there's a term for it. And of course, I can't remember what that term is right now. But it's when you're basically assert, determine. Attorneys out there don't, nail me to the cross on this because I'm forgetting what the actual term is. But you're agreeing with the other side that these are the actual facts. And they're going to ask you what you believe the property value should be. And usually that property value should have some basis in fact that you have in your hand. So if you're not ready with that, don't sit there and scramble. Be ready to tell them, this is what it says, this is what it is. Not what it should be, what I think it is. This is what I want it to be, and this is what it is. Of course, they're going to agree to disagree because they haven't seen your facts yet, unless you've given them a little booklet. And then even then, you're going to have to walk them through the finer points. You've got like 15 minutes. Okay, so have it tabbed and have it ready and be organized. If a ratio study or a comparison of a representative sample of properties appropriately adjusted for determining the median value of the appraisal must be prepared to prove an unequal appraisal. So not only do you need the evidence to support it, you need to show your calculations. And I usually do that with an Excel spreadsheet. Much easier just to show it to them, and then they use their little calculators real quick to make sure that the numbers add up. And then they trust you. You're reliable to them if you come that prepared. And it just makes it smooth sailing. You're probably going to win your case if you have legitimate, authenticated, or it can be authenticated evidence that's relevant to your property that shows that it is the value you say and not what they say, for the very reasons that we just discussed. The size isn't the right, the age isn't right, it's gone down in value, the condition's not right, they didn't use the right comps, whatever it may be. All right? Okay. The next thing is you want to look at is, did the chief appraiser deny an exemption? Could be that you're not having a problem with the actual market value, but your taxes, there's an exemption that's not shown that you believe that you qualify for. All right. First, find out why the chief appraiser denied your exemption request. If the chief appraiser denies your homestead exemption, for an example, obtain evidence that you owned your home on January 1st and used it as your principal residence on that date. If the chief appraiser denied a homestead exemption for part of the land around your home, show how much the land is used as a part of your residence. If the chief appraiser denied a homestead exemption for age 65 or older, disabled persons, disabled veterans, spouse of a military member killed in action, or spouse of a first responder killed or fatally injured in action, read about the qualifications for exemption in the Comptroller's Texas property tax exemptions. And you can Google that and find it. I will tell you this. In Texas, when you claim a residential homestead exemption, back in the old days, you could do it in each county if you wanted to cheat the system. You could have your residential homestead. You could have one in Montgomery. You could have one in Harris. You could have one in Fort Bend. You could have one in Waller. And so you got this beautiful exemption that capped your value from going up more than 10%, plus you got a reduction in taxes with the exemption in all these different counties. Well, that changed probably about a decade ago, maybe 2 decades. It's been a while, because they require that you provide your driver's license, and your driver's license, unless you're pretty swift, you're not going to be able to go and get it changed to show you live in these different areas. So I guess it's in your best interest to show that your homestead is where your most expensive property is, if you're doing that primarily to save on your taxes. That would be a way to beat the system. I don't know that many wealthy people that really care that much about it, that want to argue. There's just not, it's too much trouble to do that, especially if you get caught when you're lying. And if you've got a job where you're an attorney or a doctor, your integrity is in question. So it's really not worth it. But, you want to consider that. You may, if you have a number of properties, you won the lotto and now you've got all these big properties, you may want to move into the property that is the most expensive. And with the homestead, if it's a rural homestead, you can keep 200 acres around that homestead. If it is an urban homestead, you get to keep 10 acres. So if you have 12 acres, like many people have over 10 acres in Montgomery County, and because we have a lot of ranch land out here, and that goes for Waller and I think Walker, San Jacinto, Grimes. Many counties have lots of people that have lots of large properties over 10 acres, which I guess at that point they could be deemed rural, and so they get the 200 acres. But if you're in Montgomery County, odds are you are not rural. You are, particularly if you're in the Woodlands, or if you're in, or if you have over 10 acres in many of the nicer subdivisions out here. Sendera Ranch, Red Oak Ranch, anything with the name ranch in it. You only get to homestead 10 acres of your urban residence. I don't believe that you can homestead an urban and a rural. You don't get to divide it up. It's either your homestead or it's not. I can't say that for a fact, though, and that's a good question. I'm going to look that up. So what that means is that you get the tax break on 10 acres, and they also, if somebody sues you, they can't sue you for more. They can't take away. They can take away anything you're not exempt from a person you have a judgment against from taking property away that's outside that 10 acres that you've designated as your homestead. So kind of be aware of that too. You may want to put the property that's in excess of 10 acres perhaps in a trust that would protect you in the event that you got a judgment against you, so that so you're judgment proof, basically. And I have lots of people that cheat the system that I have judgments against that do that kind of thing. So that does work. All right, so exemptions are one way you can fight it, though, kind of get back on track here. Let's say the chief appraiser denies your agricultural appraisal for your farm or ranch. So let's say you own 15 acres and you want an exemption on the extra 5 that you can't get your homestead on. Or let's say you want a double exemption. You want your homestead and an agricultural. And so you plant strawberries, right? And you have to meet certain criteria for that. And so to find out why the appraiser denied your application, you need to review what the qualifications are. The agricultural appraisal laws have specific requirements for property ownership and use. Prove that your property qualifies for special appraisal based on its productivity and intensity of use. Gather your ownership records and management records, or obtain information from local agencies that provide services for farmers and ranchers to show why you qualify. All right. Another one is the chief appraiser determined that you took your land out of agricultural use. And that kind of reminds me of in land development, like rollback taxes. You've got that's a big thing when you're doing land development, because it was used as a cow pasture and they got like some cow exemption, whatever that may be, livestock exemption, and which they do have. And then it's sold to a developer who puts residential houses on it. Well, the appraisal district says, hey, you don't get the benefit of the previous 4 years of agriculture because now it's residential. And so now you're gonna pay rollback taxes. And there's no interest on it. It goes back, I believe, 3 years. But it's something to consider. If you're buying land and you're completely changing its use, you may have to pay additional taxes that are different from the use that it had the exemption for. It doesn't just stay that way. It changes if it's used for a different use, right? And so if agricultural activity still taking place on your land, if you have taken only part of the land out of agricultural use, you may need to show which part still qualifies. If you are letting land lie fallow or show that the time it has been out of agricultural use is not excessive or is part of a typical crop or livestock rotation process for your county, that you should still get the exemption. See, it's kind of specific to argue that. So you need to look at the qualifications for it and argue your point if you can win that. And you do get, the exemption is good. If you can qualify for it, go put strawberries on your land and try to get that exemption, or whatever that use may be. Do it. Don't just hold land and have no exemptions on it, because you need to get the, every chance you get, you want to save money on land use your land. I mean, that's what it's there for. You don't want non-productive land. I think, what we've gone over in this show before, over and over again, it's what Gerald O'Hara said to Scarlett, that the land is the most important thing on earth. There's nothing more important than land. And, you can find all these biblical quotes to the value of land. Land really is important. God gave us land. He wants us to use it. You don't use it, you lose it. Okay, so another thing that you have to look at is to see if it's worth filing a protest. Do the appraisal records show an incorrect owner? We kind of went over that briefly before. Provide records of deeds or deed transfers to prove ownership. If you acquire the property after January 1st, 2021 for this year, you may protest its value before the protest deadline. The law recognizes both the old and the new owners as having an interest in the property taxes. Okay, and another bullet item is your property is being taxed by the wrong taxing units. An error of this sort often is simply a clerical error. For example, the appraisal records may show your property as located in one school district when it's actually in another. And a case in point is the property, the area that I live in, looks like it's zoned to the Woodlands, but our particular subdivision, when it was developed, said we don't want, our little enclave did not want to be a part of Woodlands. We are surrounded by Woodlands, but we said no, because and I didn't understand that, so I asked the old timers that were there, why are we not in the Woodland School District? And they said it was because we wanted our kids not to have the competitive edge in a school district where they could be the valedictorian, and we didn't think that the chances were as high with, as though people with money have smarter kids. I don't know why they did that, but do look at that. That may be an issue. They may have the wrong mud district. They may have the wrong school district. They may be double taxing you, county and mud, city and mud, and that kind of thing. So look at that. It's important. Another thing to look for is your property incorrectly included on the appraisal records? Some kinds of taxable personal property move from place to place quite frequently. Property is taxed at only one location in Texas. You can protest the inclusion of your property on the appraisal records if it should be taxed at another location in Texas or even out of state. Okay. Another thing you want to look at is the chief appraiser or ARB failed to send you notice that the law requires them to send. You have a right to protest if the chief appraiser or the ARB fails to give you a required notice. Make sure that the appraisal district has your correct name and address. A notice is presumed delivered if sent by first-class mail with the correct name and last known address. In some instances, notices are sent certified mail, and the date of delivery is shown on the return receipt card. The timeliness of communications is determined by the post office cancellation mark. And this goes with the way things are sent in court and discovery as well. So the receipt mark of a common or contract carrier or other proof it was deposited with the carrier. If you prove that you did not receive notice, the appraisal district must prove that it mailed the notice properly. You cannot protest failure to give notice if the taxes on your property are delinquent. Before the delinquency date, you must pay a partial amount, usually the amount of taxes that are not in dispute. You may file an oath of inability to pay the undisputed taxes, and the ARB will hold a hearing to determine if the prepayment would constitute an unreasonable restraint on your right of access to the ARB. And that's where we kind of get into one of your reasons for a constitutional appeal, where you might be able to move up the appellate court, scale, I guess, or pyramid, if you have a constitutional reason of unreasonable restraint, you didn't receive the notice and they didn't let you protest. But I will tell you this: if you didn't receive a certified mail notice and they say, "Oh, look, we didn't get we sent it and we know it was sent because we didn't get it back," if they didn't get it back, then they can't. First, if they got it back, you obviously didn't get notice. If they didn't get it back, they don't know that you got notice. It could have gotten lost in the mail. It could have been put in the wrong mailbox. It could have been stolen from your mailbox. It could have been destroyed. They can't prove that they sent it to you with nothing in hand. The only thing they can prove if they didn't certify mail it is if they got it back that you didn't get it. So it's a pretty high burden for them. And if you missed your date, you can pretty easily say, "I didn't receive it." And it's going to be up to you not to let this linger on for several years. Obviously, you owe taxes. But if you've just missed the date by, a few weeks, a few months, and you say you didn't receive it, then that's a good argument. If it doesn't by certified mail and they can't prove, if you didn't receive it, it's unlikely if they were sent by certified mail that you would know it was there because you're going to get the green card. And you didn't get it if the green card just got dropped off and it got blown off in the mail or anything, or however the mail works. This works with jury summons also. If you get a jury summons and it's sent regular mail, how in the world would they be able to prove you got the jury summons, right? Okay, so anyway, it's not it's a way to get around it, but it's kind of your last chance. And I'm just telling you how the system works. Another thing you want to look at is the appraisal district or ARB took any other action that affects you. You have the right to protest any appraisal district action affecting you and your property. For instance, the chief appraiser may claim your property was not taxed in a previous year. You may protest only those actions that affect your property. And this is worded kind of weird because he's saying that the chief appraiser may claim that your property was not taxed in the previous year. And then their explanation is you may protest only those actions that affect your property. Well, the action is only for that year. He can't come back. That would be out of the scope of what you're arguing about. They can't, unless the taxes are delinquent, which would be evident, then they've got a valid point. If no tax has been paid and you can't prove they were paid, then that's going to be your burden of proof. But if I guess they're saying that if the chief appraiser may claim that your property was not taxed at all in the previous year, that's just kind of a dumb argument. I don't even know why they threw that in here. It's going to be obvious. Either the taxes were paid or they weren't, and it's going to be your burden of proof if you say you paid them. So you can't. That's going to be the poor man's argument. Don't even go there. How do I file a protest? The chief appraiser must publicize annually the right and the methods for protesting. We all got these there. If you didn't, they're very good about, once you get the actual notice, telling you how to protest step by step in a manner designed to effectively notify all appraisal district residents. However, try to discuss your protest issue with the appraisal office in advance. You may be able to work out a satisfactory solution before even appearing before the ARB board, which you could do, but they're so busy right now, I kind of doubt that would actually happen, but you should give it a shot. So you file a written protest. That can be via email, and you can actually do that on the appraisal sites that are online. There's like a little toggle tab. File your notice to protest by May 15th and no later than 30 days after the appraisal district mailed a notice of appraisal to you, whichever date is later. But if you've missed it, you can motion for a continuance or leave to file later because you didn't receive it. That would work because if they didn't, if they sent it regular mail, they won't be able to prove otherwise. Or if you have a legitimate reason, if you're sick or in the hospital or COVID, they probably will grant it. They're pretty good about that. If the chief appraiser sends you a notice that your land is no longer in agricultural use, you must file the protest within 30 days of the date which the chief appraiser mailed the notice. It's a little bit different for agricultural. If you file a notice of protest before the ARB approves the appraisal records, you are entitled to a hearing only if the ARB decides that you had a good reason for failing to meet the deadline. If you do not file a notice of protest before the ARB approves your appraisal before they approve the appraisal records, you may lose your right to appeal. These are some kind of details that are on their appraisal notices. I highly recommend that everybody go to the Texas Comptroller's office or to your appraisal district, Montgomery County Appraisal District here, and actually look at these. They've got it all bullet point on their site for you to look at. So this is going to be our last segment on appraisal protest. Next week, we're going to be doing property owner associations and commonly asked questions and directors and officers and when they do right and when they do wrong and what kind of liability they have. I think it'll be a really interesting show. So we'll see you next week, Tuesday at noon. And remember, the most important thing you can do this week is to serve God by serving others. We'll see you next week.